Picture this, one parent gets a new job interstate or wants to be closer to their own family overseas. They're excited, hopeful, ready for a fresh start, but the other parent suddenly feels like their relationship with their child is about to be ripped away. Instead of weekends at the park or school pickups, they're facing plane rides and long gaps between visits. These are the kinds of relocation cases that walk through our doors every week, and they're often some of the most heartbreaking disputes in family law. My name's Hayder Shakara, I'm the director at Collective Family Law Group, and today I'll walk you through what the courts look at in relocation cases and how to protect your rights and your child's well-being. With the 2023 reforms under the Family Law Act, the old presumption of equal and shared parental responsibility has been removed. Now courts must take a more shorter and focused list of what's in the best interests of the child into account when there's no starting position of equal and shared parental responsibility. As a result, relocation cases are judged more flexibly based solely on what serves the child's best interest in each case. Let's start with a parent who wants to move. Relocation is not something you can just go ahead and do. If you pack up and leave without consent or a court order, you run the risk of being ordered to return immediately. And judges don't look kindly on parents who take matters into their own hands. So what does the court look at when deciding whether to allow a relocation? Genuine reasons like employment opportunities, better support from extended family, or escaping family violence are taken seriously. Just wanting a fresh start isn't usually enough. Of course, one of the largest things to consider is the impact on the child's relationship with the other parent. If the move means the child will lose significant contact, you'll need to show how you'll keep that relationship strong and together. Some ideas might mean longer holiday visits, video calls, or covering travel costs for the child or for the parent. If you're going to want to relocate, you're going to have to show the court that it's going to improve your quality of life and the quality of the life of the children that are moving as well. Courts want evidence, better schools, safer living arrangements, more stable finances, not just promises. We acted for a mother who wanted to relocate from Sydney to Brisbane after separation. She had strong family support there, better job prospects, and a childcare plan that gave her financial stability. The father in that case opposed the move, and we had to establish that this was going to be the best thing for the child. And in that case, the court did approve the move because she could clearly show and had the evidence to support that the relocation would be the best thing for the child's welfare. Now let's flip the situation and go on the other side. What if your ex tells you they're moving with your child and you don't agree to the move? The first thing you should know is that courts will always look at the depth of your relationship with your child. If you're actively involved doing school pickups, attending sports, spending quality time each week, that's powerful evidence. Relocation might severely damage that bond, and judges take that very seriously. If you're opposing, here's what you need to do. Don't wait. Get advice immediately and lodge an application to stop the move if necessary. Show your involvement. Document your role in the child's life, the day-to-day parenting, not just the weekend visits. Challenge the practicality. Can the other parent really afford the move? Is the schooling or living arrangements actually better? Sometimes the claims don't stack up. We represented a father whose ex wanted to move overseas with their child. She argued it was for job opportunities and family support, but the court looked at the child's stability here, school, friendships, and the strong bond with the dad. The relocation was refused as a result of it. That's the reality. Unless there's a very strong case, courts are reluctant to approve moves that cut a parent out of the child's life. So no matter which side you're on, there are a few universal steps you need to take. Don't make unilateral decisions. Courts act quickly to reverse relocations done without consent, and if you're acting alone. What you should try first is mediation and exploring different options that could give both parents what they want. Sometimes parents agree on a longer school holiday time, shared travel costs, or more virtual contact to make it work. Next, you need to get legal advice early. These cases are technical, emotionally draining, and expensive. The sooner you understand your options, the better positioned you'll be. Relocation cases are some of the most challenging in family law. They strike at the heart of what matters most: your time with your child. At my family law firm, we've handled relocation disputes across Sydney and Australia, both for parents seeking to move and those stopping to fight it. Every case is unique, but the principles remain the same. The child's best interests are always at the center, and if you're focusing on that, you've got a strong chance of winning your case. If you're dealing with a relocation issue, don't wait until it's too late. Get advice now. Subscribe to our channel for more insights into family law, and if you need help with your matter, reach out to us directly.